Hello guys, hope you're all doing good, your preparations are going good, and I hope you're all set for your exams. So trying my best in however way I can help you to make your exam pressure easier. So now today what are we going to take up? What I've done is, people, from your RTPs, MTPs, model test papers, the previous question papers, have tried to take all the questions from the company law and have tried to keep all the unique questions, and yes, more or less I've tried to take all the questions. So I think from the exam's point of view, these questions will have the maximum weightage. Over and beyond this, I wouldn't say that they can't ask question, but this is the pattern. So if you can imagine, I've taken up the questions from past papers, model papers, MTP, mock tests, and your RTPs. So if I've covered all four, you will get a fair idea of how the questions are being asked from company law. So I really think beyond this there might not be any other question asked, but yes, from your exam point of view, let us try to keep it up very short, and these are the maximum questions. I know you guys also would want this. So I'll attach this PDF in the description below. You guys can download it as well. So let us start. There is no more delay. Okay. Mr. Raj formed a company with a capital. Okay, 1 second. Okay, Mr. Raj formed a company with a capital of 50,000. He sold his business to another company for 40,000. For the payment of sale, he accepted shares worth 30,000. The balance 10,000 was considered as loan, and Mr. Raj secured the amount by issue of debentures. His wife and 3 daughters took 1 share each. Owing to the strike, the company was wound up. The assets of the company were valued at 6,000. The debts due to unsecured creditors were 8,000. Mr. Raj retained the entire sum of 6,000 as part payment of loan. To this, the other creditors objected. Their contention was that a man could not own any money to himself and the entire sum of 6,000 should be paid to the outsiders. Examine the rights of Mr. Raj and other creditors who will succeed. What is the answer, people? The answer is nothing but, if you guys know, now whenever you are presenting the answer in the exam, now how do you present? People always remember, again, the 100th time I am telling you in my videos, try to classify your question into 4 paragraphs. The first paragraph, people, will always be the provision, meaning what does the law say? Here you will be writing as per section so and so of Companies Act 2013. And what does the law say? In this paragraph, you are going to define everything about the law. You are not supposed to use any of your own words here. After the provision is done, next I will be writing something called as facts. Facts is nothing but, people, whatever is given in the question itself, break that into 1 or 2 lines or max to max 3 lines, not beyond that. Always remember, the facts has to be as less as possible. And remember, the provisions has to be given the maximum weightage. It can be as maximum as possible. Now, what is the third paragraph? Let us imagine, if at all in the question, whatever the facts they have given, if it is similar to any of the case laws you guys have studied, then try to quote the case law here. I will write it as landmark judgment. So if at all there is any place where you think the question is similar to, then you can quote the landmark judgment here. Now in the given case, it is quite clear that the case law that they are asking you is Salomon versus Salomon and Company Limited. Now that is where my case law will go. The last paragraph will be, people, conclusion. In the conclusion, I will be writing, referring to the facts, provision and the decided case law. We can say, see, they would have asked you in the question itself. What have they asked? Examine the rights of Mr. Raj. Mr. Raj is right in keeping the particular, 6,000 rupees. The Raj's contention is right and the creditor's contention is wrong. Because remember, the doctrine here is what, people, once the company is incorporated, then the concept of separate legal entity comes into picture. So from that day, people, the shareholder is different and the company is different. So the creditors cannot say that the shareholders and the company are one and the same. Once the company is incorporated, whatever is your rights will be the same thing for me also. We both are outsiders only to the company, and that is what is the answer here. Is this clear, all of you? Pakka? 100%? Okay. So what is the case law here, people? Remember, it's Salomon versus Salomon. So the creditor's contention here is wrong. Yes. Next one, BC Private Limited and its subsidiary KL Private Limited. See, whenever they ask you a question of subsidiary company or government company, write down the chart. So what are they telling you? There is a company called as BC Private Limited. BC Private Limited, okay. And its subsidiary, there is a company called as KL Private Limited. And its subsidiary KL Private Limited are holding 90,000 and 70,000 shares in PQ Private Limited. See, there is one more company, it's something called as PQ. In PQ, BC is holding 90,000 shares. KL is holding 70,000 shares. Okay. The paid up share capital of PQ Private Limited is rupees 30 lakhs, that is 3 lakh equity shares of 10 rupees each. Okay. Analyze with reference to the provision of Companies Act whether PQ Private Limited is a subsidiary of BC Private Limited. That is, see, question number 1. Always remember, you need to see in the question, open your eyes, clearly see how many questions are actually asked in the question. See, that's the question number 1. Next one, see, what would be your answer if KL Private Limited is holding 1,60,000 shares in PQ Private Limited and no shares are held by BC Private Limited. See, there is a question number 2. Now what I will write, my first thing, people, my provision will be, I will try to answer what do you mean by subsidiary company. A company where the majority of the board of directors, basically the composition of the board is controlled by another company. Next one, when one company holds more than 1/2 of the total voting power, either on its own or together with its subsidiaries. See, the total paid up capital of KL, they have given us 3 lakh shares. How much does BC and KL together they are holding? They are holding 90 plus 70, and that is equal to, people, 1.6 lakh. Half is 1.5. They are holding 1.6. Definitely they are holding more than 1/2, people, and because of this, in the first thing, people, we can say that yes, the KL Private Limited is a subsidiary company, sorry, not KL, PQ Private Limited is a subsidiary company of BC Private Limited. That's my conclusion number 1. Conclusion number 2, what if they are asking you the KL Private Limited itself holds entire 1.6 lakh and BC holds nothing? Remember, people, that will be the third case, deemed subsidiary company. In my class, I would have given you example. Walmart is a shareholder in Flipkart. Flipkart is a shareholder in Myntra. So Walmart need not hold anything in Myntra. Still, Myntra will be considered as a deemed subsidiary company of Walmart. That's my conclusion number 2. Is this clear? All of you? Pakka? That's my answer. Okay. Third one, a company ABC Limited as on 31st March 2025 had a paid up capital of 1 lakh. Okay. In June 2025, ABC Limited had issued additional 10,000 equity shares. Okay, they had 1 lakh plus they issued another 10k, which was fully subscribed. Out of 10,000 shares, 5,000 of these shares were issued to. Out of this 10,000, 5,000 was given to whom? It was given to XYZ Private Limited. XYZ is a holding company of PQR Private Limited. This is a holding company of PQR Private Limited, it seems. Okay. XYZ is a holding company of PQR Private Limited by having control over the composition of board of directors. Now PQR Private Limited claims the status of being a subsidiary of ABC Limited. They're telling you PQR is claiming to be a subsidiary of ABC Limited. Okay. Now PQR Limited is claiming the status of being a subsidiary of ABC Limited as being a subsidiary of its subsidiary, that is XYZ Private Limited. Examine the validity of the claim of PQR Private Limited. Yes, what is happening, people? See, there is a company called as ABC Limited. It has a paid up capital of 1 lakh, that is it has 10,000 shares. So it is actually having 10,000 shares. In 10,000 shares, they have further issued another 10,000 shares. So totally how much, what is the paid up capital of ABC? ABC has 20,000 shares. Yes, sir. And which was out of 10,000 shares, 5,000 shares were given to XYZ. So 5,000 is given to XYZ. Okay. XYZ is a holding company of PQR Private Limited. Okay. By having control. Now PQR Private Limited claims the status of subsidiary of ABC Limited. Of course, people know because they both are nowhere related. Where is PQR and where is ABC Limited are related? Nowhere they are related. So no, this contention is wrong. Okay, state the relationship, if any, between ABC Limited and XYZ Private Limited. They are asking you, what is the relationship between XYZ Limited and ABC Limited? ABC Limited totally has 20,000 shares. In this, 5,000 shares are given to XYZ Limited. Correct? That means how much? Out of 100%, 25% is given to XYZ. Then what is the relationship between ABC and XYZ? ABC is an associate company of XYZ. That's the answer. Clear? Hello? Okay. Do you agree that a company is an artificial person? Elucidate, meaning expand. Also explain the authorization of Beta Limited, a company incorporated under the Companies Act, can be made in ease. Can be made in case it does not have a common seal. It is an artificial person. Of course, once it is registered, it is an artificial person. Separate legal entity. Can sue, be sued, enter into a contract, can hold property in its own name. Everything will come. Yeah. Next one is, people, what is the alternative for common seal? 2 directors have to sign. If at all there is a company secretary appointed, then it shall be 1 director and 1 company secretary who shall sign in the place of common seal. Done. Next one, see, Narendra Motors Limited is a government company. Shah Auto Private Limited have share capital of 10 crore in the form of 10 lakh shares of 100 each. Narendra Motors Limited is holding 5,05,000 shares. See, there is a company called as S Private Limited. Their total shares is 10 lakh. Out of this 10 lakh shares, 5,05,000 shares are held by Narendra Motor Limited. Okay. Shah Auto Private Limited claimed the status of a government company. Advise as legal advisor whether Shah Auto Private Limited is government company under the provision of Companies Act. So people, you guys have seen under what is that the definition, people, that if there is any subsidiary company of a government company, that will also be deemed to be a government company. So Narendra Motors Limited, people, is a government company here. Now, first thing, always remember, people will write off the definition of directly government company here. You guys need to write the definition of subsidiary company also here. Why? First thing, you need to know whether the Shah Auto Private Limited, does it confirm to be the subsidiary company of Narendra Motors Limited? See, I am holding 10 lakh shares. When will I be called the subsidiary company? When I hold more than 1/2 of the total voting power. How much is 1/2? It is 5 lakh. What do you mean by more than 1/2? 5 lakh 1,000. How much is that I am holding? 5 lakh 5,000. So I am definitely holding more than 1/2 the total voting power, and hence I can be considered as a subsidiary company of Narendra Motors Limited. Now because Narendra Motors Limited is a government company, the subsidiary of a government company will be deemed to be a government company, and hence yes, Shah Auto Private Limited can claim the status of government company. That is my answer. Clear all of you? So I will be writing in my provision, I will be writing majorly, I will be writing subsidiary company definition. Yeah, and then facts and then conclusion. Okay. Next one, XYZ is a company incorporated under Companies Act. The paid up capital of is held by as under this. I have done it 100 times, people. There is a company called as XYZ. In this, the paid up capital is held by various people like the citizens. One is Government of India, central government is holding 20% of the capital of XYZ. Next one, there is another company called as LIC, which is holding 8% of the capital. Next one is Government of Tamil Nadu. It is holding 10% of the capital. Next one is Rajasthan. This is holding 10% of the capital. And next one is people ABC Limited. Technically this is a government company and this is holding people 15%. Now they are asking you whether XYZ is a government company or not. What do I mean by government company, people? Whenever not less than 51% of the paid up capital is held by central government, state government, central and state, or various state governments. Now in the given case, I will add to become a government company. See, it should be held by central government, state or center and state. So add this 20. Tamil Nadu, add 10. Rajasthan, add 10. People, see, these are not given in the definition. When a government company holds the shares, you need to add it in the 51%, nowhere the definition says. And hence my shareholding, people, is just 40% the government is holding, and hence I cannot call this as a government company. XYZ does not become a government company. Okay. Next one, Stuti Textiles Private Limited is a wholly owned subsidiary of SST Limited. See, STPL is a wholly owned subsidiary of SSTL. Okay. It has only 5 members and restricts the right to transfer their shares to any person other than the person who is in employment of the company. Some members oppose the decision of the company as they want to invite a group of people to subscribe the shares in Stuti Textiles Private Limited. Decide with reference to the provisions of Companies Act whether the restriction of the company to transfer the share is correct. Actually a very tricky question, people. What is this? See, this is a public company, this is a private company. Now you guys know, you all know by now that if there is a subsidiary of a public company, it will be deemed to be a public company. Agreed? Now in the given case, what is the challenge, people? Now because it is a public company, this is a deemed public company. Now what is the problem? See, if you are a private company, then there is a restriction on you to transfer the shares. But if you are a subsidiary of a public company, you will be considered, you will be assumed to be a public company. That means what? There will be no restriction on transferability of shares. Now the question here is, people, whether in the subsidiary company, can there be a restriction on transferability of shares or not? Remember, people, in our exam, in your answer given by the institute, they have given both. They are saying the restriction is valid, the restriction is invalid. They have given you both the perceptions. So exam point of view, whatever you write is valid. That means if you write subsidiary of a public company, hence it is a deemed public company. In a public company, there cannot be a restriction on transferability of share. If you write that contention, it is valid, the restriction is valid. The restriction is invalid because it is a deemed public company. Suppose you write, no, even after it being a public company, the basic nature of private company won't change. If you are writing that as your perception, then people, the restriction will be valid because it will be treated as a private company only. Now this is according to your institute. But if you guys are asking my opinion, sir, what is your opinion? What is right? My opinion is, people, this restriction of transferability of share, even after you being a subsidiary of a public company, the restriction will be still valid only, because the basic characteristic of a private company will not fade away. You are still treated as a private company only. Because if that is not the case, this is a deemed public company, no, then you should have written the name as STL. Then why did you write it as ST Private Limited? So those basic characteristics won't change. You will still be a private company. Restriction is not, it is still valid. If you are a private company, you cannot go for an IPO. Just because you are a deemed subsidiary company, that doesn't mean you can go for an IPO. That doesn't mean you can invite offer from public. All this is still not possible. I hope you are getting it. Hello? Yes. Okay. That is in my point of view, but in an institute point of view, of course, it is very deep for your level. That's why they have given you an alternate answer. Both are right. Next one, the paid up capital and turnover of Aradhya Cosmetics Private Limited for financial 24-25 is 4 crore and 45 crore. What is that? Capital and turnover. Okay. Directors of ACPL decided not to follow some provisions as it is a small company according to section 285 of Companies Act. The company secretary of Pooja Fashions Private Limited contended that ACPL is not a small company as ACPL is a holding company. Decide whether ACPL Cosmetics Limited can avail the status of small company. First thing, people, for your attempt, remember the limits will be 4 and 40 only if you guys are writing it in May. If you guys are writing in the month of December or any time after that, then people, the small company limits will be 10 and 100. Remember that. Paid up capital will be 10 and turnover will be 100. For May it is 440. Once May is done, it is done actually. So what will be in the next thing will be 10 and 100. Remember that. Okay. So the paid up capital and turnover. Paid up capital is 4 and turnover is 45 crore. Here only it is not a small company. Correct? Then how can it qualify as a small company? That is one. So the criteria itself is not satisfied. The second thing is, people, if certain companies cannot be called as a small company, what and all, according to section 2, section 2 clause 85, a small company, people, cannot be a public company, cannot be a holding company, subsidiary company, and section 8 company and a statutory company. Now these companies cannot qualify to become a small company. So in the given case, it is neither satisfying the limits and they have clearly given that it is a holding company. So hence you cannot be called as a small company. Correct. The company secretary's contention is valid. The paid up share capital of Abhinav Natural Gases Limited is 140 crore. The holdings of central government and Maharashtra government are 40.10 and 30.20. If you add, how much is it coming to? It is coming to 70.30. Okay. Respectively, in one tender relating to natural gas, the directors of ANGL quoted it as a government company. Decide according to the provision of Companies Act whether ANGL can be tagged as a government company. Remember, people, out of 100 students, 90 students will write this as a government company only. But in reality, is it a government company or not? For that, you guys have to do one thing, people. I need to calculate. If not, now what is that? When will you be called as a government company? Not less than 51% has to be held by state to center or both of them together. In the given case, what is happening, people? What is 1/2? 70 is 1/2. What do you mean by more than 1/2? I need to check, people, how much does 51% come to in 140 crore? How much is 51% of 140 crore, people? Have they calculated somewhere? If they have not done, we will do. So you take 140 and you do 51%. It comes to, people, 71.4. They have done no. Yes, sir. Now how much are we holding? 70.3. How much is 51%? 71.4. So people, they are not holding more than 51. I mean, they are not holding minimum 51 percentage. Hence, I cannot call it as a government company. Now, why did I say 90 people will write it wrong? Because people remember, to become a subsidiary company, you can just to hold 50.1, you will become a subsidiary company. But to become a government company, you have to hold 51 at least. I hope this is clear. Pakka. So in the given case, it is not a government company. Okay, Ram, from exam point of view, people, small company, for your attempt it might not be that important, but for September and onwards, the small company will also be important. For September, it is very, very important because the limits will be new, the high chances of asking. Now, because the limits are old and outdated, for this attempt, the small company limits being asked is rare, but still no and go. Government company, dormant company, all these are very important. Okay, Ram wants to incorporate a company in which he will be the only member. According to the Provision of Companies Act, what type of company can be incorporated? Basically, OPC related provisions. Okay. M&N holding 70 and 30% of the shares in the company both died in an accident. Answer with reference to the Provision of Companies Act. What will be the legal effect on the company? What happens, people? Perpetual successions. Members may come and go, but the company will go on forever. Next one, Kamal, a chartered accountant, started his e-commerce business by incorporating a OPC on 1st October 2023. He being a sole member of OPC, his brother Sudhakar with his consent. Okay. People, for this, I want you guys to watch one video. On YouTube, people try to type OPC resident in India or otherwise. Resident in India or otherwise. You will get one, 4 minutes video. Try to watch that. I have given complete clarity about this question. Yeah, for OPC, if you guys are watching, very, very important, try to watch that. Next one, XYZ Limited was incorporated to hold the patent for a new product. The company is expecting to start its commercial production within the next 2 years. In the meanwhile, for timely installation, the company has placed a purchase order for plant and machinery with a down payment of rupees 1 crore. Referring to the Provision of Companies Act, whether the company can acquire the status of dormant. Section 455, people, what is that? A company which is incorporated for a future project or to hold any intellectual property, and a company which is not having any significant accounting transaction. What do you mean by significant accounting transaction? Any money paid other than for your registrar's filing fees to satisfy any other legal requirement for maintenance of office and records and for share allotments. If you have paid money for these four, it is not a significant accounting transaction. If you have paid money for any purpose other than these four, it will be considered a significant accounting transaction. In the given case, they have clearly given that we have made a down payment of plant and machinery for 1 crore rupees, people. Then you have made a significant accounting transaction, and hence the company does not qualify to get the status of dormant. JV Limited borrowed a secured loan of 5 crore from Star Bank Limited to meet its working capital requirement. However, the borrowing powers the company under its MOA were restricted to 1 crore. So maximum you could borrow is 1, but they have borrowed 5. The bank released the loan amount in 2 installments of 1 and 4. On the due date for repayment of the loan, the company refused to accept the liability of 5 on the ground that the borrowing was ultra vires the company. The company's books of accounts show that the company has utilized the loan amount of 3 crores for the repayment of its lawful debts. The utilization of the remaining 2 crore cannot be traced. Referring to the doctrine of ultra vires under the Companies Act, examine the validity of the decision of the company denying the repayment and explore the remedy, if any, available to the bank for recovery of the loan. Remember, people, if it is an ultra vires transaction, of course it does not create a debtor-creditor relationship. So the company, what they are saying is right, provided the company should have not utilized that money. So in the given case, if there was nothing given, 1 crore company is liable because that is as per the MOA. for the 4 crore company will not be liable. That is in a normal scenario. But in the given scenario, what are they telling you? The company has clearly utilized the 3 crore rupees to pay their other debt systems. You have utilized it, no? Then people, they're telling you, whenever you have utilized it, people, and if you have a record for that, for this you are liable. But whereas the 2 crore rupees, there is no record of how, where, what the money has been utilized for. For this 2 crore, you cannot hold the company liable. Now, what is the other remedy available? Now, this is the first remedy. 3 crore company is liable. Other remedy, people, the directors will be personally liable for all such a frauds. Clear? Okay, next one. Harmony Foundation is a newly incorporated company focused on promoting education and healthcare services in rural areas. The company is registered as a Section 8 company with a clear plan to reinvest all profits into its activities. And the license has been accorded by the central government for the financial year ending. Okay, the company earned a substantial profit and transferred some amount to associates, a partnership firm and one of the member of Harmony Foundation. Subsequently, on the complaint of one of the members, the CG, after giving an opportunity of being heard, directed the company to be wound up on the ground that the partnership firm cannot be a member of Section 8 company and it cannot transfer any part of the profit to the firm. Explain in the light of the provision whether the ground taken for the winding up is sufficient. Remember, people, now off late, because the questions and all, most of it are being generated using AI tries to put all the information in the question only, like the one we are just seeing. See, they are only telling you, if not, there is no way a lot of people will know that a partnership firm can become a shareholder in a Section 8 company. That's the only exception. A partnership firm cannot be a shareholder in any other company. The only exception is, people, your Section 8 company. When AI forms a question, the AI tries to put everything in the question itself, and it will ask your opinion, that's all. So I don't know if you guys have to feel lucky or not, but yes. Why did I say that? Because if there is one student who has studied everything and gone, he would have written that point on his own. Now AI is helping you, it's giving you a hint. So yes, I feel that is a little unfair. That should not be the question, because it is easier now to pick it up. But yes, end of the day is, if it's going good for all of you, then why not? Correct? Okay. So in the given case, a partnership firm can be a member. If CG has taken that as a ground, then no, people, that is not a valid grounds for winding up. Whereas a Section 8 company, if it is earning profits and if it is distributing it as a dividend, now that is a valid ground for winding up. In the given case, both the grounds are considered and hence it is not valid. If you are taking it up under one ground, that is valid. Section 8 company can be a member. Partnership firm can be a member. Can become a member. Okay. Next one, Sunrise Infra Limited was incorporated with the object of developing residential housing projects as specified in its MOA. The board of directors decided to invest a substantial part of the company's funds in speculative trading of shares of other companies, hoping to earn quick profits. Whether the shareholders, when the shareholders questioned this act, the directors argued that since the company was duly incorporated and had wide powers of management, their decision was valid. Examined with reference to the doctrine of ultra-vires. See, this is what I say. They only give you everything. Whether the director's actions is binding on the company. Of course, people, doctrine of ultra-vires. The company's MOA clearly says we are into developing residential housing. But what did they do? They utilize the money for speculative trading. What can the shareholders do? The shareholders can go and get a stay order. Injunction. What is you would have seen a question, no? You would have seen in the book, whenever a company does ultra-vires, what is the effect of ultra-vires transactions? The shareholders can go and get a injunction telling the directors to stop from whatever they are doing. That is one possibility. The second possibility is, people, whatever the directors are doing, for that the company is not liable. For the entire thing, the directors only will be held liable. So yes, whatever the director is doing is ultra-vires. They will be personally liable, not the company. Bharat Infrastructure was incorporated in India with 55% of paid up capital held by CG, 20% by SG, and the remaining 25% by private investors. Some private shareholders argued that the government control was not absolute and therefore the company should not be classified as government company. Because it is a government company, because first point itself is a government company. So 55 plus 20 is definitely a government company. See how many times a government company provision has been asked. I don't know if you guys are realizing that. Mr. Dhruv was appointed as an employee of Sun Moon Timber Private Limited on the condition that if he were to leave his employment, he will not solicit customers of the company. After some time, he was fired from the company. He set up his own business under the proprietorship and undercut Sun Moon Timber Private Limited's prices. On the legal advice from his legal consultant and to the refrain from the provisions of breach of contract, he formed a new company under the name 7 Stars Private Limited. In this company, his wife and a friend of Mr. Dhruv were the sole shareholders and directors. If you guys know these people, it's a cut copy paste story of Gilford Motor Company versus Horn. That's the case law. What are the case law for people? Lifting of corporate wheel, under which one people, whenever the company is used for doing anything which cannot be done directly, or if the company is utilized for any fraudulent purposes, the corporate wheel can be lifted. Case law people, Gilford Motor Company versus Horn. Yeah, that's a case law. I'm not just going through. AK Private Limited has borrowed 36 crores from BK Finance Limited. However, as per MOA, the maximum borrowing power of the company is 30 crore. Examine whether AK Private Limited is liable to pay his debt. State the remedy if any available to BK Finance Limited. People, this is again one more question asked in your exam only. In this, they have said people, here they are given AK Private Limited is not therefore liable to pay the debt. Remember people, according to me, this answer is wrong. See, your MOA says you can borrow up to 30 crore. And if you have borrowed 35 crore, now the question is, why did you borrow this money for? Is it for the objects given in the MOA only? If the answer is yes people, then the company will be liable up to 30 crore because you have borrowed it for the objects of the company. Whatever is beyond your power, for that the company will not be liable. That is for 5 crore it will not be liable. But the question, the answer given by the institute says the company is not liable at all. In my opinion, and I think that is right also, that this answer is wrong. This interpretation is wrong. Anything beyond the power, the company will not be liable. Within the power, company should be liable. So in the given case, for 30 crore, company should be liable. And what is the alternative for the 5 crore? The 5 crore can be recovered from its directors. Always remember, directors will be unlimitedly liable. Mike LLC incorporated in Singapore, having an office in Pune, India. Analyze whether Mike LLC would be called as a foreign company. Answer is yes. What do you mean by foreign company? A company which is incorporated outside India, and if it has a place of business in India, whether physically or electronically or through an agent, we call it as people a foreign company. So you have a place of business in India, so you will be called as people a foreign company. Yes. Ratanmul Milk India Limited is a public company and formed on this day Mr. Sharman was appointed as a legal advisor of the company. It was mentioned in the articles of association of the company that Mr. Sharman will not be removed. Mr. Sharman will not be removed from the post of legal advisor till 31st March 2027. However, on 1st July 2024, a special resolution was passed for alteration in AOA and Mr. Sharman was removed from the company. Mr. Sharman filed the suit against Ratanmul Milk India Limited for removal as legal advisor. Referring to the provision of Companies Act, whether can company remove Mr. Sharman? In the given case, people, they have given that Mr. Sharman cannot enforce any right against a company and company had right to remove him by making alteration in AOA. That is what they have given. So in our question, in our institute guideline answer, they have said people that yes, the company has a right to remove Sherman. But according to me, the reasoning given is people wrong. They said you can alter your AOA and you can remove Sherman. But I'll tell you people, you need not even alter AOA. You can directly remove Sherman. In this regards, there has been even a Supreme Court judgment in real life. So whenever I say, I will always say with facts, or else do you think I am mad to come and keep your institute ka guideline answer and tell it is wrong? So what is the right interpretation? Remember, whenever there is AOA, whenever there is MOA always binds outsiders to the company. AOA binds the internal people, the shareholders, the directors to the company. Whereas this person, whoever is his legal advisor, he is neither a shareholder, he is nor a director. So who is he? He is a random outsider. So AOA does not give you any right, people. The outsiders cannot claim anything based upon AOA. What is given in AOA? Because AOA is not meant for you. It is meant for the internal people, that is shareholders, that is for directors. It's not meant for the consultants or any random outsider. So even though I say I will not remove you in my articles, that is an internal matter. That has nothing to do with you. If I have entered into any agreement with you, then yes, you come and challenge me. Then I will be liable. Because AOA, remember, what is Indian Contract Act? It is a contract between two parties. AOA is a contract made by the company, within the company. Did the advocate come and sign AOA? No. Then you were never party to the contract at all. You are always an outsider. So AOA is a wrong document. So because of that, anything given in the articles does not bind the outsider. On those grounds I am telling you, you can remove the legal counsel, that is advocate, absolutely fine. So the answer, the question, the reasoning given is wrong here. Okay. XYZ Limited was incorporated to hold the patent for a new product. The company is expecting to start its commercial production. Similar people, already we have seen Dormant company, down payment, significant accounting transaction. It's not a small company. Not a dormant company. Mr. Ramesh Saluja incorporated a private company under the name Saluja and Sons Private Limited with himself, his wife and children as shareholders. Same thing people, Salomon versus Salomon, whatever we saw there. A company ABC Limited as on 31st March 2025 had a paid up capital of 1 lakh, that is 10,000 shares. In June 2025, ABC Limited has issued additional 10,000 shares. We have already seen this, people, repeating. Associate company, that was answer. Okay, next one. HP Polytech Limited has a paid up capital divided into 6 lakh equity shares of 100 each. 2 lakh equity shares of the company are held by central government and 1 lakh 20,000 are held by government of Maharashtra. 6 lakh, totally they are holding 3 lakh 20,000. Correct? Okay. Now explain with reference to whether HP Polytech can be treated as government company. Just the first thing you need to do is what is 51% of 6 lakh people. That is what you need to count. We'll see whether if they have calculated. The holding of the 3 lakh 20,000, which is more than 51%. So I am not calculating it. You guys do it. If the 51% is coming to somewhere around say 3 lakh 10,000. And if this number is 3 lakh 20, then definitely it is more than 51% and hence you can consider it as a government company. Next one, No Limit Private Company is incorporated as an unlimited company having a share capital of 10 lakh. One of its creators, Mr. Samuel, filed a suit against the shareholder, Mr. Innocent, for recovery of his debt against No Limit Private Limited. Mr. Innocent has given his plea in the court that he is not liable as he is just a shareholder. Explain whether Mr. Samuel will be successful in recovering his dues from Mr. Innocent. Now what are these people? Try to understand what they are telling you. This is an unlimited company. In an unlimited company, the shareholders' liability is unlimited. You cannot say that I will not pay and all. However, there is a way. So whenever a company is liable to any person, imagine a creditor, the creditor cannot directly go and file a case on our shareholder because you do not have any direct relationship, privity of contract. Then what is the right way? The creditor has to file a case on the company will recover it from the shareholder and that money will be given to the creditor. The shareholder is liable, unlimitedly personally liable, but remember it cannot be a personal and direct suit. Clear? Okay, that is an unlimited company. Remember that. Tycoon Private Limited is a holding company of Glassware Private Limited. As per the last profit and loss account for the year ending 31st March 2025 of Glass Private Limited, its turnover was 1.80 crore and paid up capital was 80 lakh. The board of directors wants to avail the status of small company. The company secretary of the company advised the directors that the glassware cannot be categorized. Of course, people, because you are a subsidiary or a holding company, both of you cannot be considered as a small company. As simple as that. In the Flower Fans Private Limited, there are only 5 members. All of them went on a pleasure trip into a boat open sea. The boat overturned. Everyone lost their life. What to do? What will happen? The company will continue. Correct? Okay. Company perpetual succession. That is the answer. An employee, Mr. Karan, signed a contract with his employer company, ABC Limited, that he will not solicit the customers after leaving the employment of the company. This is nothing but people, again the same thing, Gilford Motors versus Horn. That same thing is repeating again. Yes, lifting of corporate veil. Pacific Motors Limited is a government company. Rama Auto Private Limited is a private company having share capital of 10 crore in the form of 10 lakh shares of 100 each. Pacific Motors Limited is holding 5 lakh 5,000 shares in Rama Auto Private Limited. Rama Auto Private Limited claimed the status of government company, advised as a legal advisor. Same thing you need to do. What? Share capital of 10 crore in the form of 10 lakh shares. Total is 10 lakh shares. In this, 5 lakh 5,000 shares are held. 5 lakh 5,000 shares are held. So Pacific Motor is a government company. So subsidiary of a government company will be a deemed subsidiary company. More than 1/2 you need to hold. So 5 lakh 1 share is also more than 1/2. Now because it is a subsidiary of a government company, it will be a deemed subsidiary company. So it is a deemed government company. So here only I am telling you, do not get confused. I hope you guys got a clarity on that. When you are checking the subsidiary company definition, you guys need to check more than 1/2. So 50.1 is also more than 1/2. 50.001 is also more than 1/2. It will become a subsidiary company. But to become a government company, you need to hold at least 51%. That's the difference. Clear? In the given case, it will be a government company. Prasad incorporated an OPC to run his new startup. OPC borrowed 50 lakhs to meet its long-term fund requirements and 25 lakh to meet its working capital requirements on the basis of its project from a NBFC. But due to some running hardships and new government policies, OPC has failed to pay its debt to NBFC. Assets of the company were insufficient to pay the outstanding debts. According to the provision of Companies Act, decide whether Prasad would be liable to pay the outstanding debts of NBFC in the following circumstances. If the NBFC proceeded against the personal assets of the Prasad only on the ground that he is the only shareholder, can he directly proceed? No. Limited liability people. The company will be liable and not the shareholder. So the shareholder will not be liable. If the NBFC proves that the OPC was formed for the fraud and cheating, yes. In such case, yes, the shareholder can be held unlimitedly liable. But you cannot directly sue. You have to go through the company itself. MTK Private Limited is a company registered under Companies Act 2013 on 5th Jan. The company did not start its business till 31st July. Okay, 5th Jan 2022, 2023, 2024, more than 2 years. Identify under which category MTK private limited company is classified. Explain the definition of the category. Nothing but they're telling you, whenever a company is inactive for more than 2 years, we classify such company as a dormant company. Section 455, that's the answer. Yes, it will be treated as a inactive company. They can apply for a dormant status. The paid up capital and turnover of Aradhya Cosmetics Private Limited for 24-25 is 4 crore and 45 crore. Okay, respectively. Which we have already done it, right? You cannot. First of all, the limits only does not allow you, because both have to be satisfied, and holding subsidiary and all definitely not possible. The paid up share capital of Abhinav Natural Gases is 140 crore. The holdings of central government, which we have already seen. Yes, repeating. The state government of X. See, can you see the number of questions on government company? The state government of X, a state in the country, is holding 48 lakh shares of Y Limited. The paid up capital of Y Limited is 9.5, that is 95 lakh shares. Y Limited directly holds 2,50,600 shares of Z Private Limited, which is having a share capital of 5 lakh shares. Z Private Limited claims the status of subsidiary company of Y Limited as well as a government company. Advise as a legal advisor whether Z Private Limited is a subsidiary company of Y Limited as well as government company. See what I am telling you. There is Y Limited. The Y Limited totally has 95 lakh shares. In this, 48 lakhs are held by the state government, correct? Now what is that? I'll calculate, people. In 95, what is 51 percentage? Directly I'll calculate that. 48.45 is considered as, people, 51 percentage, correct? So this is not a government company, first thing. Okay. Y Limited directly holds 2,50,600 shares of Z Private Limited. So there is Z. In this, people, total they have 5 lakh shares. In this, how much is Y holding? Y is holding, people, 2,50,600. Yes, it's a subsidiary company because holding more than 1/2 of the total voting power. Okay. Next, Z Private Limited claim the status. Okay, Z is claiming the status of subsidiary company of Y Limited. Yes, it is subsidiary company. But is it a government company? Answer is no. Because Y itself is not a government company. That is our answer. Correct? Is subsidiary but not a government company. See, a classic question. See, people, this is what I have taken, people. Lab maximum. I have at least compiled some 18 to 20 question papers. Yeah, these are the total number of questions, and see the question that is coming out of government company. Sir, but if we do, is it sufficient? People, always remember, from the exam point of view, day before the exam, this is what maximum I can say. Let us hope for the best. It is always good to know that this is what they are asking and go, and rather than feeling what they are going to ask, having no clarity. So you know now these are the possible questions. Now if I have to tell you what are the important topics of company law, these are the important topics. You know what are the maximum asked questions. Lifting of corporate wheel, you have seen a question. Small company, government company, dormant company. Yes, indirect based questions. So in types of companies, no and go, there will be a question. It is clear, all of you? So that's it for this particular video, and that is within 1 hour. That's a very good revision of all the concepts to you guys. And so wishing you guys the best, do well, and yes, let us hope for the best. Thank you so much. See you all. Bye bye.